we have an A to Z law firm protection. We call it protecting the protectors. So from A to Z, we'll help protect these law firms that are protecting the widows and orphans and injury victims. So one of the most important documents that we have is basically sample legal fee agreement for their contingency fee. What that allows the attorneys to do is protect them if there is a structured settlement, so that they anticipate the structure, they value it. How is it valued? Usually it's the cost. Allows them to take their legal fee up front if they need to. And most importantly, the plaintiff knows all up front that a structured settlement may well be presented, and there's already a process in place to value that structure and to protect the plaintiff. The second element that's very important about our legal fee agreement is about taxes. Some attorneys are not very comfortable giving tax advice. So we put in there, if you don't want to provide tax advice, just say so right there. Another thing are about trusts and Medicare and Medicaid elements. There's also protection language in there also for the attorney's law firm to make sure that they have addressed those important issues and the client is fully aware of it. So the second document that's unique, I think, to my firm is, we call it a mediation stipulation. It does several things. Number one, if in fact everybody can settle on a cash amount and walk away from that, but there might be a need for a structure to be done, a structured settlement to be done, we have special language in there for that mediation agreement that allows that to happen. That's a fantastic financial planning vehicle because it takes the heat off of everybody, where you don't have to make a decision, a lifelong decision, at 5 o'clock on Friday night in the judge's chambers or at the mediation offices. Gives you a little bit of breathing room, and it still preserves the tax benefits for a structured settlement. There's some standard forms out there, and over the years I've developed my own special form that I have that has some protection language built into the settlement agreement. One is, what about if there's a late payment? Well, some language has just standard language that kind of leaves it hanging out there. I have specific language that says exactly what happens if there's a late payment and the process of getting that done. The other thing that I do, and this is more up to the people involved, if they want appropriate language to take care of commutation, for example. Very important to put the commutation language in the settlement agreement and the court order and the assignment agreement and maybe even the application, so we make sure we have that in there as well. And down the road, if there are changes in people's lives and there's financial situation, we talk with the plaintiff directly and say, what kind of language would you prefer to put in the settlement agreement on this issue, and we tailor it to meet those needs. So this is a periodic payment attachment, we'll call it, let's say, and it is an attachment to either your petition or your court order, and we've developed some special language in there that protects the plaintiff on a couple of different levels. Number one, unrelated to a structured settlement, is what if the plaintiff dies before this court order is entered? Something similar to the stipulation at settlement. We always put in language in that stipulation and in the court order. What if the plaintiff dies before this order is entered? Well, we make sure that there's language in there accordingly. More important on the stipulation than the court order, of course. But most importantly for that court order stipulation of periodic payments is what we call I call it special funding language. What's that? What that is that if the check is not arrived properly on the purchase date, we have special language in that court order that still allows this specific court order, even though the numbers are going to change because of the funding has now been delayed. We have special language in there that still allows that court order to be used without any further hearing or going back to the judge for another hearing or an order. And we have special language that my clients have been found very, very useful sometimes, where there's just been a delay by no fault of anybody. We're still able to use that court order. And we found that to be extremely helpful in many, many cases. So our structured settlement survey form is simply a survey of all the markets, all of them, not just A plus or not just A, but A and A plus by AM Best rating, so that the attorney knows exactly what is available in the marketplace. That's important on two different levels. First is that it's their due diligence. It shows the judge, we've looked at all the markets and here it is. Secondly, as some people may know, some property and casualty companies prefer to use only a select group of companies. Well, if that is the case, then the attorney should be aware of that and make the appropriate decisions based on that preference from the defense side. But if they do not have the full survey, they would not be able to make that choice that's in their client's best interest. The settlement protection letter is a letter that the attorney will, it's a tough letter to write, to be honest with you. It's a letter that an attorney will probably write to protect their firm. It protects their firm when a client may go against the advice of an attorney on, let's say the client wants $10 million up front and they'll take care of that for the rest of their lifetime. Well, that may or may not be an appropriate decision, but if the attorney and the attorney's advisors inside the law firm and their own internal partners or counselors find out, gee, maybe that's not the best way to go. It's a letter that is handed and given to the plaintiff and said, well, you had the right and you did meet with advisors. You rejected this way to protect the $10 million. So we just need you to sign off on that this is your decision, so that everybody is clear that it is your decision, which is of course their decision to make. But for such a large amount of money, it's probably a good idea to at least look at other options. The lawyers, they know the law inside out. There's absolutely no doubt that they are truly advocates for widows and orphans and injury victims in this country. And sometimes we help them stand side by side to say, you have the legal expertise and we have some financial expertise, and together we can work to make sure that your client is protected on both levels. You do the law, we'll do the numbers, and we'll help your client get a financial plan from this potential settlement so that you're protected and your client's protected, both of you.